So what is meant by persuasive precedent? To understand that, we firstly need to understand what is meant by a precedent, what is meant by binding precedent, and then we can begin to explore what is meant by persuasive precedent. So in this video, we'll be exploring the following three questions. We'll be asking, what is a precedent? What is a binding precedent? And then finally, what is meant by persuasive precedent? So what is a precedent? Simply put, a precedent is a decided case. Every day cases get brought to our courts. Sometimes it takes as little as a day or two for a decision to be reached, and sometimes it takes months or years for that decision to be reached. But nevertheless, a decision is always reached. And once that case has been decided, once a decision has been reached, that decided case or that decision is technically a precedent. But not all precedents have the same status. Not all precedents have the same significance. For some precedents are binding and some precedents are not binding. So what do we mean by binding precedent? So in order to understand when a precedent is binding and when a precedent is not binding, we need to explore the doctrine of judicial precedent. And we're going to explore that while we look at this very important structure, and that is the hierarchical structure of the courts in England and Wales. So that is going to appear on my screen now. And as you can see, at the top of the structure, we have the UK Supreme Court, which is formerly the House of Lords. So if you're reading any cases that were decided before 2009, you will see House of Lords, HOLS, in your textbooks, right? That UK Supreme Court, or this UK Supreme Court, sits at the very top of the hierarchy. And when the House of Lords was in action or in existence, the House of Lords sat at the top of the hierarchy. Now, what does the positioning of each court mean with regard to precedent? According to the doctrine of judicial precedent, every court is bound by the decisions reached by courts higher up in the hierarchy than them. So what I mean is, for example, if you are in the Crown Court and a precedent is reached or the case is decided in the High Court of Justice or the Court of Appeal or the Supreme Court, you are bound to follow that decision. That is binding precedent for you. However, judges in the Supreme Court are not bound by precedents passed by judges in the Crown Court, nor the Magistrates Court, nor the County Court, nor even the Court of Appeal, because the doctrine of judicial precedent says courts higher up in the hierarchy create binding precedents for courts lower down in the hierarchy. These precedents are law and must be applied when judges lower down in the hierarchy encounter or have cases in front of them with sufficiently similar material facts to the material facts in the binding precedent. When judges have cases with sufficiently similar material facts in front of them to a binding precedent or precedent that was created or reached in a court higher up in the hierarchy than them, those judges must apply what we call the ratio decidendi of those decisions. And the ratio decidendi is the reason for that decision. So that is what we mean by binding precedent, and that is how we identify whether a precedent is binding or not. So that means a court lower down in the hierarchy, for example, the Magistrates Court, cannot create binding precedent for the Crown Court, because that's not what the doctrine of judicial precedent tells us. How do we answer our third question? Remember our third main question of the video? That was, what is meant by persuasive precedents? Now, you could define it as follows. You could say a persuasive precedent is a non-binding precedent which judges can choose to follow if they see fit. The English legal system wants judges to follow binding precedents We want consistency and predictability in the English law. But there are times when judges need to be flexible and they need to depart from the strict rules of the doctrine of judicial precedent. And they are allowed to do so by following precedents which are not normally binding. And they can argue or they can state that they were persuaded by these precedents. Let's see if you've been following. Can the Court of Appeal create binding precedent for the UK Supreme Court? And before the UK Supreme Court existed and we had the House of Lords, could the Court of Appeal create binding precedent for the House of Lords? No. No. Because the doctrine of judicial precedent doesn't state that courts lower down in the hierarchy create binding precedents for courts higher up in the hierarchy. That's not what it says. But what if you're in the House of Lords and a precedent has been set, a decision has been reached in the Court of Appeal, which is technically lower down on the court structure than you are. But you and your colleagues know that this is a fair decision, and you know that this decision is necessary for the development of the law and for the change in social ideas. What do? You can follow that precedent. You don't have to, but you can. You can say that you are persuaded by that precedent reached lower down in the court structure. So this is one example of persuasive precedent. Precedents created lower down in the hierarchy are definitely not binding precedent for courts higher up in the hierarchy, but they can be persuasive. Courts higher up in the hierarchy can choose to follow them. And this allows for some flexibility within the English legal system. And one example of that is R&R from 1991, when the Court of Appeal created precedent which stated that a man could be found guilty of raping his wife in English law, and the House of Lords was persuaded by that precedent, so they followed the Court of Appeal's decision. And question number 2. Which part of a judgment is binding precedent? Is it the ratio decidendi, the reason for the decision, or is it the obiter dicta, all the other things said? It's the ratio decidendi, the reason for the decision. The doctrine of judicial precedent tells us that when judges have a case with similar material facts in front of them, and they have a binding precedent to apply, they apply the ratio decidendi of that decision, that decided case, not the obiter dicta. But what if the obiter dicta in a very significant case seems right to apply to a case in front of you? What if you're a judge sitting in a court and you look at some obiter dicta from a particular judgment and you think that that obiter dicta is fair and that the law needs its application? Can you apply it? Yes, you can. You don't have to apply it because it is not binding precedent, but you can apply it. You can be persuaded to apply it. So that's our second example. The obiter dicta of a judgment can be persuasive precedent. Now, finally, do you remember seeing a court named the Judicial Committee of the Privy Council on the hierarchical structure of the courts in England and Wales that I showed you? No, because it is not part of the hierarchical court structure in England and Wales. So can this court create binding precedents for courts in England and Wales? No, it can't. But this court is so important that it can create, and it does create, highly persuasive precedent. Meaning that judges in England and Wales do not have to follow the precedents created by this court, but they are aware that the precedents created by the Judicial Committee of the Privy Council are highly persuasive. And they are highly persuasive because of the history of this court and because of the fact that the majority of judges that function in the Judicial Committee of the Privy Council are in fact the same judges that function in the UK Supreme Court. So this is another example of persuasive precedent. This court cannot create binding precedents for courts within the hierarchical structure of England and Wales because adoption of judicial precedent does not state that the Judicial Committee of the Privy Council creates binding precedent. But because the judges in the Judicial Committee of the Privy Council are the same judges that sit in the UK Supreme Court, and because of the historical significance of this court's decisions are highly persuasive for judges working within the English legal system in England and Wales. I hope that was useful. If you have any further questions, please leave me a comment in the comment section. If you like the video, don't forget to like, share, and subscribe, and leave a comment. If you don't know what to say, just say, I love law with Denise.